Terminating a commercial lease in Queensland is a complex legal process governed by contract, statute, and equitable principles, and cannot be undertaken lightly or mechanically. A breach of a commercial lease does not automatically entitle a landlord or tenant to terminate. The right to terminate depends on the seriousness and the nature of the breach, whether the obligation breached is essential, and whether the conduct amounts to repudiation. Courts assess breaches in context, focusing on whether the conduct goes to the root of the lease or indicates an unwillingness or inability to perform future obligations. Even where a serious breach exists, termination must strictly comply with the lease's termination provisions and any applicable statutory requirements. Many leases require formal notices to be issued. Opportunities to remedy the breach must be given, and precise procedural steps must be followed. Failure to comply with these requirements can render a termination invalid. Delay and inconsistent conduct can also defeat termination rights. Accepting rent, continuing negotiations, or otherwise affirming the lease after becoming aware of a breach may amount to an election to keep the lease on foot, potentially waiving the right to terminate. Because termination ends the tenant's right to occupy and may expose the terminating party to claims for damages if done incorrectly, courts treat lease termination cautiously. Wrongful termination can result in significant financial and legal consequences. Careful legal analysis is essential before attempting to terminate a commercial lease to ensure compliance with contractual, statutory, and common law requirements, and to minimize the risk of liability. Contact us today for a free 30-minute consultation with one of our experienced team of commercial lease dispute professionals, and let us help you protect your rights.